Welcome back. Today, a string of 8-year-old robberies in Detroit now has new meaning nationwide. The Supreme Court ruling against the government this morning, holding that law enforcement agencies generally need warrants to collect location data from cell phone companies. Privacy advocates say it's a big win and, in their view, a big check on growing government surveillance. Chief Justice John Roberts, writing for the majority, argued that the data enables the government to, quote, travel back in time and conduct, quote, near-perfect surveillance of suspects. Our senior legal analyst Jeffrey Toobin joins us now. Jeff, 5-4, so a closely divided court, but a significant decision nonetheless. Walk us through it.
Well, you know, it's really one of these great cases where the Constitution, which was written in the 18th century, has to be applied to the world of this. And, you know, it is not an easy thing to do. And it's not surprising that the court split 5-4. Basically, what Chief Justice Roberts said is these phones are essentially parts of our body now. And even though we know in some abstract way that we can be traced, our whereabouts can be traced, it's not fair for the government to do that without a warrant. And he joined with the 4 liberals. It was an unusual split in terms of the court. You had John Roberts with Ruth Ginsburg, Stephen Breyer, Elena Kagan, and Sonia Sotomayor against the 4 more conservative justices, saying, you know, we're not going to ban the government from tracing people's whereabouts with their phones, but if they do it, they have to get a warrant first.
They have to get a warrant first. And so, Jeff, this is going to be in legal cases in the next 5, 10, 15, 20 years. Privacy is going to be a huge issue, tracking of surveillance. Does this apply just to the government and law enforcement, or are there any implications for business, which of course collects all of this as well?
Well, it's not directly addressed in terms of applying it to the private sector, but certainly it's relevant. And it also, you know, this is a moving target. I mean, remember, these cases only come up when the technology existed for trace. It's not just, you know, the law was mostly about phone calls. You know, when the government can trace phone calls. But we've moved beyond phone calls because the mere fact of carrying a phone is evidence now. The government can track your whereabouts. That technology is only going to get more advanced. And people are so, yes, we know what the answer is for cell phones now, but none of us can predict how how exactly the technology will evolve, and the court will have to address that. But this certainly is a stop sign, or at least a yield sign, when it comes to law enforcement, saying you don't get free access to absolutely everything about us. We are going to insist, that is, we, the Supreme Court, are going to insist you at least have to get a search warrant under these circumstances. That's not a big barrier for law enforcement. It's not difficult to get a search warrant, but it is a way of saying to law enforcement, you can't rummage around without at least involving a judge getting permission.